Okay, a problem with the project has come up. There is a dispute between the contractor and the owner. Which of the following are possible ways that the dispute might be adjudicated? This is one of those ones where it's not just a choose one out of the four. This is where you choose multiples. And so there are multiple correct answers here. So in a situation where there's a dispute and the dispute needs to be sort of figured out and somebody has to decide who's the winner of the dispute, there are a couple of very simple, straightforward answers to this situation. And then there's a couple other ones that are a little bit, a little looser. So let's sort of run through the possibilities. The first one, if anybody answered A, that's a little bit of a cheat on my part. I actually, when I was putting these together, I did a typo, and then I realized that it was actually kind of funny, so I left it in. So A says meditation, and meditation is probably a great way to go through dispute resolution. I would recommend it for everybody, but that is not going to be a possible answer on the NCARB exam. But mediation absolutely is. So G is certainly correct. Mediation is going to be the relatively low scale effort. It's going to be a sort of the simplest way in terms of when you have a third party reviewer come in. It's somebody that both parties can agree to. And when we talk about dispute resolution in this way, we're usually talking about a dispute between the owner and the contractor, though it could be any number of other players as well. But if it doesn't say specifically, you should assume that it's between the owner and the contractor. And so a mediation would be a situation where the contractor maybe chooses 3 different people to be a mediator, and the owner then chooses one of them, so that it's somebody that both parties agree to. They have enough sort of separation, standalone separation. But it's a relatively simple and low-key process. The mediators, they tend to be people who are like retired architects or retired contractors, so they have a lot of information already. They already know how things work, and now they're going to go through the documents and figure out what happened, and then they're going to, sort of, after they talk to both parties, do something similar to depositions. They're then going to make a decision. And that decision is sometimes binding, although not usually. Usually, if the parties don't agree to what happens with the mediation, it can then jump up to the next level. And the next level would either be arbitration or litigation. And it depends on the contract and a few other issues, but arbitration and litigation are the two next level dispute resolution setups. Litigation is obviously when you go to court. Arbitration is a lower level than going to court, but more intensive than doing mediation. So I essentially have something akin to a judge. In some jurisdictions, they actually call them judges. In others, they call them other arbiters and a few other terminology points. But arbitration is where you might have either a single person or a panel of 3. And it's a much more laborious process than mediation. But litigation is going to be even more, and is going to cost a lot more in terms of time and money. So mediation you might be able to get done in a month. Arbitration, maybe it takes 5-6 months, something like that. Litigation is going to be years because it just takes a long time to get onto the calendar, and you have a lot of lawyers involved. So it's much more expensive. So the reason that mediation and arbitration exist is so that you don't have to get to litigation. And some contracts will mandate only arbitration, some will mandate mediation and then litigation. You know, there's a bunch of different ways it can happen, but those 3 are the sort of the main 3 in terms of dispute resolution. But we're looking for 4. So then the question comes, which one is the other one? We already got rid of meditation, although, like I said, I like that one. If we look at C, So I'm going to cross out A. If we look at C, C is REPC. That's actually a real estate purchase contract. It has nothing to do with it. Real estate purchase contracts are often the thing that goes into litigation because that's just the nature of them. So they often show up there, but it's not a way that you would go through a dispute resolution. So A and C are definitely not it. Let's look down at the bottom. How about a lien? A lien is an interesting decision. A lien is something that is used, a mechanics lien it's usually referred to as a way to sort of start the dispute resolution process, but it's not how you would get it adjudicated. So a lien is a situation where, just as an example, let's say the owner didn't pay the general contractor and the contractor is owed $100,000 and they keep working for a little while, but then they still haven't gotten paid, and so something's not right. So they put a lien on the property. And so what that means is that they're saying, look, something's like we're owed money from this owner / property. And so we're going to claim ownership by saying we're putting a lien on this. It rides with the deed so that anything that's going to happen on that property, any legal thing, try to sell it, trying to pay taxes, all of those things, that lien is going to show up on any legal thing that's happening on there. And it's a way to sort of tell the owner in that situation, we're serious, we want to get paid, you can't just ignore this. So it would start the process, but it's not the way that you would actually adjudicate the dispute. So lien is an interesting possible answer, but it's not really the correct fourth answer. And then we have barrister review and IDM. Well, barrister review just means a lawyer review. So anybody involved in any adjudication process is probably going to have a lawyer involved. Even if you have mediation, you're probably going to have a lawyer involved. So that just means you're reviewing with your lawyer. So that's not it. So then the only one left here for us is E, and that's the IDM, the initial decision maker, which is such a sort of bogus sounding name. But it's this kind of interesting thing that was put into the contracts. It sort of existed before, but then in the 2007 contracts, interestingly, the AIA contracts come out every 10 years on the 7. So in 2017 is the next set. But in the 2007 contracts, they very significantly sort of put into place this idea of the initial decision maker, and it's typically considered to be the architect. So the idea is this dispute comes up before we really get into mediation, or especially into arbitration or litigation, before everything gets too out of hand and everybody's losing money and the project is stopped dead while we try to figure out what's going on. Instead, we go to the architect, and the architect takes off of their I'm an agent of the owner hat and puts on their IDM hat, meaning they're a professional, they're supposed to be able to look out for the health, safety, and welfare of everybody, and they are the initial decision maker. They are like a mediator, but just somebody who's part of the process, and now they are able to sort of help adjudicate this process. And if the different parties don't like it, then it can jump to mediation or arbitration. But IDM is definitely the fourth of this particular example.
Well done with meditation.
Yeah.
I think you got some people on that one for sure.
Sorry, I apologize.
You're also evil.
Yeah. Well, and actually, let me be clear that on the actual exam, they won't do that. They're not going to try to trick you like that. The reason I included it is because I just thought it was funny, because meditation would be actually a pretty good way to resolve disputes. But they're not going to try to trick you like that. They will trick you in ways like lien and the barrister review. These are all things that are part of the dispute resolution process. And so there will be correct answers, but there will be more correct answers. And that's always the trick is, sometimes you see one, you're like, oh, that's it. right? And then you have to just remind yourself to go and keep looking through to find the
It's
other
one of those
one.
exam sort of techniques is make sure you read everything carefully, like Jason said in the comments here. And also one of the questions along the similar lines of, are they going to kind of, one question came through for IDM, and then you put in parentheses initial decision maker, so you typed it out. One of the questions was, are they going to try to maybe be a little tricky and like not write out initial decision maker? And my thought is, no, they're probably going to be explicit about it.
Yeah, I would imagine they would be explicit about it. I got to go back and forth on this. One of the things in the sort of previous versions of the exam, there's been a lot of discussion about how a lot of the questions were this kind of gotcha type question that was like something you had to know. And not something that but in most situations, architects can look things up. And so you don't necessarily need to be able to, memorize all of these things. So they have tried to move away from that and into situations where it's more about just kind of understanding what the ideas are, and then you can sort of answer these questions. But of course, it still makes a difference if you can remember the different titles.
And for those of you who are ready to start preparing for the ARE, and if you're already an AIA member, you can use coupon code 32917PMYT to get a 15% discount for the entire duration of your ARE exam prep membership. And then finally, leave a comment below the video to let us know what you think. Share any suggestions you may have. I promise we'll read every word that you write and use them to tune our next episodes. So thanks for watching.